All right, let me call to order, if I might, public meeting 129 of the Massachusetts Gaming Commission. This meeting is one we called last week after we received some communications from the city that I'll ask Ombudsman Ziemba to talk to us about and describe for us in a second. But it is primarily because of the need to meet in a public session to decide on almost any strategic plans that we make. So this is basically an administrative meeting, but we're meeting here because of the need to do so in a public session, in a public setting. So Ombudsman Ziemba, would you simply outline for us what the communications that we got that were essential in triggering this meeting today?
Sure, Commissioner. So as you know, last Thursday was the deadline for the parties to submit their best and final offers to each other, the WIN applicant and the City of Boston. And late Thursday afternoon, we received a communication from the City of Boston that it determined that it was not going to participate in the arbitration process. The WIN applicant did submit their best and final offer to an agent of the Commission. And thereafter, on Friday, Council Blue had communications with both the applicant, the City of Boston, and the Mohegan Sun applicant that the Commission would have a meeting today to discuss the filing by the City of Boston the prior day. Since that date, we have had conversations with both the WIN applicant and the City of Boston in anticipation of today's meeting. At issue, we discussed that although I could not predict what the Commission would discuss today, we would like to discuss with them how they could participate in any discussion of impacts relative to the WIN applicant's application in Everett to the City of Boston, and measures that would be necessary to mitigate any such impacts. In those conversations, the WIN team offered to explain to the Commission its best and final offer and the reasoning behind that best and final offer and what it was including in that best and final offer to mitigate impacts. We've also had, as I noted, a conversation with the City of Boston, and the City of Boston has determined that it would not participate in a process by which we would try to learn about the impacts of the facility and the measures that would be necessary to mitigate those impacts. Also of note is that there were recent filings by both applicants, their so-called MIPA filings. For the WIN applicant, they submitted their final environmental impact report filing with MIPA. Comments for that report are due on August 8th from agencies and other affected parties. It's anticipated that a MIPA decision would be issued on the 15th of August under their schedule.
The MIPA decision, for the benefit of those watching in places removed, is the Massachusetts Environmental Protection Act process that everybody has to go through. It has periods of filings and then comments and then decisions, and this is the final stage for the WIN applicant. Yeah. Okay. Anything?
One other thing I failed to mention is that we also issued a request for comment. A couple of weeks ago, we had both of the applicants appear before the Commission, and they gave extensive briefings about their transportation plans. And as we stated at the time, we asked for public comment on those transportation plans. We asked for what do they look like? Are there any improvements that anyone from the public would offer? The deadline for those comments is August 1st.
All right, so we'll monitor those and we'll have those comments no later than August 1st. That's a helpful platform for looking at what brought us here today. Let me just add a couple of other components of that platform. This surrounding community process has been ongoing for some time and is designed to lead to a negotiated contract, really, between an applicant and a surrounding community designed to mitigate the adverse impacts of whatever casino goes up in the host community and also designed to deal with whatever the two sides, the city and the surrounding community, think is an appropriate way for the surrounding community to be compensated for things that may happen in the future. And a lot can be done in a surrounding community agreement that can't be imposed by either arbitration or by the commission. And we've seen that on a number of occasions thus far. So reaching a surrounding community agreement has many benefits that can't be reached in any other fashion. If the surrounding community agreement can't be reached, then the arbitration process kicks in. The letter that we received last week simply says, as provided by, and then there's a citation to a regulation, the City of Boston respectfully declines to participate in the arbitration process with Wynn Mass LLC. So they simply said they weren't going to participate in the arbitration process, which the commission has designed to deal with impasses and which every other surrounding community and applicant faced with an impasse has utilized, sometimes to the benefit of the applicant, sometimes to the benefit of the surrounding community, but they've utilized it. Our regulations, though this is the first time that's happened, our regulations contemplated the possibility that this might happen, and the pertinent regulation says, and I'm going to quote now, in the event a community designated a surrounding community fails or refuses to participate in the arbitration process set out in the regulations, the commission may deem the community to have waived its designation as a surrounding community, provided, however, the commission may nevertheless impose as a condition on any licensee a community impact fee and any requirements it deems appropriate requirements for mitigation of impacts from the development or operation of a licensed gaming establishment. And that's really important because it focuses on the Commission's obligations. The Commission's obligation is to implement the statute. The statute was carefully crafted to mitigate the adverse impacts of a gaming establishment on both the host and surrounding communities, calibrated in a different way, but that's what the statute was designed to do. And that outlines, as I see it at least, and I think we all see it, and we can talk about that in a second, our obligation. We have an obligation to do our best to protect the city from the adverse impact of a gaming establishment on its borders, even if the city doesn't want to protect itself or participate in the process of protecting itself. And so we have that obligation. Nobody comes in from out of town and says, these are the terms on which we're going to erect a gaming establishment. This is what we're going to do. The commission has obligations with respect to looking at the positive and negative impacts of that. The various permitting authorities have obligations, and it's the commission's obligation to make sure that all of those have a responsible role in whatever outcome materializes. So the bottom line is that we have an obligation now, whatever else happens, to try to figure out, at least as I see it, what appropriate mitigation conditions would be, and to go about that in a responsible way, given the city's election, simply to do nothing and withdraw from any participation in a design to protect the citizens from adverse impacts. So why don't we talk for a minute at a high level? It's I think too early to come up with a concrete, detailed plan for how we proceed, but let's talk a little bit about the things that we can do and should do to gather the information, really, that we need in order to contemplate and talk about and think about the conditions that will be necessary to protect the citizens of the city from any foreseeable, at least, adverse impacts. Who wants to open that discussion?
I can start and just say, look, we're well underway with our evaluation, which includes mitigation. And so we've already started to look at a number of the impacts to all the surrounding communities, and certainly Boston. So we have some of the information we need, and we'll continue to evaluate and make sure we're looking at every detail of those impacts, and that they will be mitigated properly. And I think we need to continue hearing from people, Staff can help us tremendously with that new responsibility and, reaching out, making sure we have all the information we need, and we've considered every aspect, to the best of our ability anyway, of what those impacts will be, and I'm very confident that we have the proper staff, consultants to help us with that, whether it be environmental or traffic. We've already looked at schools and housing. So we've started the process, but I think hearing from more people would be helpful as well, to make sure we're not missing something, to make sure we understand, all of the impacts.
Yeah. Commissioner?
Could we dissect a little bit that regulation, perhaps with the able help of the legal minds here? Because as you point out now, the obligation comes to the commission, and I think we are very much up to the task with a lot of information that we have or can be gathering in the near future. And I think we at some point need to talk a little bit about schedule, but we need not designate that the city has waived its designation as a surrounding community in order for us to essentially step up to the plate of understanding those impacts and assessing or reaching a solution with the applicant. Is that a fair statement?
Yes, and council can correct me if my understanding is wrong, but we don't need to do that. In fact, we have, I think, we've imposed conditions on entities that have reached surrounding community agreements in our prior licensing decisions. In those cases, there have been host community agreements, surrounding community agreements.
Right.
And we've imposed additional conditions, mitigation conditions notwithstanding that, so.
No, that is a correct description. I think the first step is to gather facts, to look at what might be appropriate conditions and get the information to do that. And a question about designation status is something that can be addressed later. It need not be discussed.
Need not be discussed.
Right.
Fair enough.
So I think what you're suggesting is we ought to really get facts and issues, talk to more people, and pursue the kinds of things we've been thinking about thus far.
John mentioned something that the applicant was willing to present their best and final offer to staff that was ready to the arbitrator, but
Yeah, they probably
we don't yet
mentioned that
have.
they would present it to the commission, what might be appropriate, given the level of detail. Perhaps we can, as a staff, we can meet with the applicant in an expeditious manner and go over all of the details of what their arguments are regarding their best and final offer and what underlies that best and final offer.
I think given some of the timing and the amount of information we may want to look at, it's much more expeditious for staff to get involved and gather as much information as possible and review it, and then get that off to the commission, so.
That makes sense. Would it be helpful to have a couple of our consultants be present as well to hear, especially if there are details about, for example, transportation, those kinds of issues? Would that be helpful?
Oh, most definitely, yes,
Okay.
we will involve them.
Well, that's an interesting format. We could, still speaking at a high level, and with more detail to come, we could certainly ask staff to do that, to reach out to the applicant, continue to reach out to the city. I mean, the city may change its mind, and one would hope that it would. They have a wealth of information that would be useful and helpful to the citizens of the city if it were brought into this process. And also to other groups who have an interest and who've expressed an interest and who've done so responsibly and thoughtfully. To reach out to them and to see what information we could get, and then perhaps have a public hearing with the commission at which we could present, ask them to present issues that would be helpful for everybody to see and helpful to us in our thinking and discussion. Because again, we can't discuss these things except among the four of us, except in a public setting. And we need to do that before the end, so. Would that make sense as a process?
That would make sense.
I think it would.
As of Thursday, or was it, yeah, as of Thursday, there were 30 days that, in our schedule, quote unquote, for an arbitration process. Is that correct?
So the arbitrations were due to last for 20 days, and then following that, there's a process by which the arbitration award could be converted to an agreement. If there was a fundamental inconsistency petition, that would be an additional 3 days parceled out, but in essence, approximately 30 days.
30 days. As we undertake this process of gathering information, perhaps scheduling the applicant to present before this commission, et cetera, is the assumption that we would accomplish that in the next 20 days or within the next 20 days? Or is it too early to even tell schedule-wise?
Well, because there is no arbitration, I'm assuming that we're not bound by those dates. Would that be accurate?
That's correct.
That's correct. I think what we would like to do is start down that process to gather some information, be able to report back to you at the next commission meeting, which is next week, as to where we are and what we've accomplished. And then maybe when we have that, we can look a little bit more closely in terms of timeframes and schedules.
But I think to your point, you're trying to get to, we're trying not to throw our deliberation week off from where it's currently scheduled and using this time frame that would have been allowed for arbitration to actually do some of this data gathering input. If we choose to take more public comment, I mean, we've obviously heard from the residents of this neighborhood about traffic issues, but there might be other issues. I think that Commissioner Cameron's point, do we need to schedule time to hear from the community on other issues?
Well, I think every one of us wants to stay on that schedule that we had for the early September decision. That the time limit is most important for completion of the arbitration process, closing the statutory host community agreement, hearing, and then moving on. As I understand that, correct me if I'm wrong. And if we're not, because there is no arbitration, bound by those closing dates for arbitration, there's no reason, A, that the city can't continue to negotiate with the applicant. The fact that they're not going to participate in negotiation.
In arbitration.
In arbitration takes away one tool, but it doesn't prohibit them from negotiating or continuing negotiations, nor does the timeline set up for arbitration require us to finish our work necessarily, we can talk about that more, necessarily by the deadline we set up to deal with the arbitration issue. So we could go on beyond with our work, beyond the early August date for ending the arbitration process and still continue to do our work before making final decisions about conditions. Am I right about that?
No, that's correct. I mean, the parties could continue to negotiate through this whole timeframe. If they're having mutual negotiations, that would be fine. The schedule, as we outlined it, assumed there would be an arbitration and then built those periods into it. But if there is no arbitration, the commission's, the really only hard dates are when you close the host community hearing, and then you need to take action no sooner than 30, no later than 90. So that's really the only hard date that you have in the timelines that flow from that.
But that's a much more succinct description than I gave. But to try and fit my point into that, there's no reason after we close the host community agreement, host community hearing, that we can't continue to work on information gathering to go into conditions.
That's right.
No necessary reason.
No, as we've done in the past, we continue to work on conditions
Right.
up until the final days of the award.
Right.
Well, especially,
Indeed, even through the hearing, we've done that.
Correct.
Yes,
Right.
that's right.
especially with the dates that you outlined initially, which are relative to the final environmental impact report, both the comments and the decision,
Correct.
correct?
All right. Mr. Stebbins, anything you want to?
Yeah, I had just two quick questions for council. So you gathered from the communications with the city that even if there was information, I understand they don't want to participate in the arbitration or these discussions or negotiations, but are they open to us asking the city for any type of data that we might need, and they hopefully would be willing to share that or provide that to us?
I think it's fair to say that they're going to watch today's proceedings,
Okay.
and that we will continue to have conversations with them to see if they can have a way of providing input to us. So we'll continue to do that.
Yep.
Again, we try to do this meeting as quickly as we possibly can, and, as things become more clear about us trying to evaluate impacts and how to mitigate those impacts, perhaps the city might provide more valuable information. But I think it's fair to say that they've decided not to participate in the initial thoughts of an outreach process that we identified to them in the last day or so.
Okay.
Do you feel like, thinking about what needs to be done in our conversation today, you have enough time to gather the appropriate information?
I think we're going to, the information has been gathered.
Correct. So it's
Much of
just-
the information has been gathered. But how you deal with some of the impacts that have been identified or that will be identified, we're going to continue to work on that. I think what our plan would be is that we report to you at our next meeting about our progress and how we stand there. Obviously, we would benefit very significantly from ideas on how the plans that have been put forward by the applicant on mitigating impacts, how people view those plans. Are they sufficient? Do they need to go in a different direction? If we have input from the neighborhood, if we have input from other groups, if we have input from the city, that would be very valuable information that in some regards we do have now, but in many regards we do not. So with the information that we've gathered today and hopefully some new information that might be forthcoming as part of the MIPA process, or information that might be available if we receive significant comments to the transportation comment period and other outreach that we do to all of those groups, we'll be able to provide you an update on where we are with information needs.
The document that the applicant recently filed, called a Final Environmental Information Report.
Impact.
Pardon me?
Impact.
Report, yeah, impact report, is about 5,000 pages long, I think, and has about at least a couple of thousand pages dealing with traffic, does it not? Is that a fair
Yes.
number? So there's a great deal of information about traffic in there. There's the traffic presentation that the applicant made some time ago. And certainly all of that information is available to us. What we need to, and there'll be commentary on that. Maybe the city will comment on that to the environmental protection folks, and they might favor us with a copy of whatever they send to the environmental people. We could certainly ask them if they would do that. But evaluating that and finding where the shortcomings are, if any, in that information would be one thing that would help us figure out what some of the conditions could be, because we know that traffic is a significant aspect of the concerns about this applicant's proposal. So we could try to do that. Other thoughts? Well, it seems to me that we have a number of avenues that we could ask staff to pursue, beginning right now, and then come back to us with a more detailed report as to what they've been able to accomplish and what maybe a more structured plan for the future would be. But they include asking the applicant to participate as in talking to us about its best and final offer, continuing to ask the city if they've changed their mind, help us with the things that they see as the main concerns here. Having the consultants review independently the information from the sources that we have. And that process, as you said, Commissioner Cameron, is ongoing now. We're meeting twice a week with consultants to look over all the material that's been filed. We can continue that process and ask them to look at the new information contained in the environmental filings. We can encourage detailed comments on the proposed traffic plans. And in fact, as you mentioned, the comments are being sought right now, and that period is open until the 1st of August. We can always extend that, given this unexpected development, and if that would be helpful. The citizens of Charlestown undoubtedly have some thoughts and comments, and there are a number of groups that have worked very thoughtfully here for years. And we could ask staff to reach out to them and get their views and inputs, and we could take a look at other surrounding community agreements. We've already done that, but take a look at them with an idea toward, are there common themes that should be and could be included in whatever conditions we impose here? And do all of that, all that information gathering and outreach, and then continue to talk among ourselves. I do think it would be helpful to have, at some point in this plan that's created, a provision for a public hearing or two, at which we could invite people to come and tell us their thoughts and try to get a little bit of a dialogue, perhaps, between people who have slightly different views on things, and craft some things that might work. It may be in the end that some of these problems can't be solved, but it may also be, and is more likely, I think, that we could find some creative ideas for many of them. And we need to do that. We need to do that to fulfill our statutory obligations. Does that make sense, that plan, Commissioner Zuniga?
Yeah. I may say the obvious here, but I'm disappointed that the parties, at least as of now, were not able to reach a negotiated agreement that, as you alluded to, Commissioner, is the best outcome, at least in theory. But I'm encouraged that our regulations anticipated, at least in the framework put forward for all kinds of instances. There's many twists and turns about surrounding community and host community. I remember nobody anticipated, and I've talked about this recently, what happened in Springfield, having more than one applicant. In this case, there's a city with 2 applicants as a surrounding community with different dynamics going on. But I think the plan that you outline in terms of gathering as much information as we can, as quickly as we can, as well as perhaps the hope that the negotiated solution is not a door that's completely shut out, is about as good as we can do.
All right. I share all of those hopes, and we'll, in the meantime, while hoping, we'll simply act and do what we were appointed to do. And I don't think we need a vote here. We're simply talking about a overall very high-level plan, and I think I see a consensus as to what the broad dimensions of that plan ought to be. Commissioner Zuniga?
You mentioned the possibility of having a hearing or two, specifically relative to traffic impacts for one, but whatever others. Are you thinking in addition or to the closing of the hearing at the host community?
I would like to explore that. I would like to explore a hearing devoted to perhaps a couple of topics that are particularly thorny, that have particularly different points of view. I'd like the staff to take a look at what they get and think about that. Maybe it wouldn't be necessary, but I would like to at least have that part of the framework that staff considers. It may not be necessary, but it may be very helpful. for people to see two reasoned approaches or three reasoned approaches to the same solution discussed in a public setting. I know that's been done, and I know that has been done over the years with respect to a number of issues affecting to the Charlestown community. But we haven't participated in it, we haven't heard it. And so if we're trying to form conditions, it seems to me we ought to be cognizant of those kinds of things. Maybe we don't need a hearing to do that, but at least I'd like that to be explored. Doesn't that make sense to explore?
That's fine.
It does, and we may hear in comments that are coming in the next week or so on transportation, what those issues are, and maybe be able to judge if the hearing would be helpful.
Yeah, yeah.
And obviously, we take comments as to other topics people in the community may want us to address that we haven't looked at yet. So that kind of agenda setting, if we do further public hearings, we'll hopefully get some feedback as to what topics folks in the community would like to have us address.
All right, sounds to me like we have a plan, at least a high-level plan, and we'll return to this at our regular meeting on the 24th, a week from Thursday. And in the meantime, we're asking staff to begin the process of outreach, begin the process of information gathering, let the community know that that's, and the city and everybody who's interested, and know that that's what we're up to. That's why people will be knocking on your door or calling on your phone. And not knocking on your door, I think, but they'll be calling on your phone or sending you a tweet. And we'll gather information, and we'll proceed to do the job that we were appointed to do. So, thank you. I guess the next step would be to ask for a motion to adjourn.
So moved.
Second.
All in favor?
Aye.
The ayes have it.